Hello students. In our previous class, we have started a discussion about essentials of valid acceptance. In that, we have already discussed first 2 points. Acceptance must be absolute and unconditional. Acceptance must be communicated to the offerer. Now, we are going to discuss third point. Acceptance must be made within a reasonable time. So, whenever the acceptor or offeree conveys his acceptance, he should convey that acceptance within a reasonable time. So acceptance to be valid, then only it will be a valid acceptance. To be valid must be made within the time allowed by the offerer. So if the offerer says that A is giving an offer to sell his car to B for 1 lakh rupees, A says that you should convey your acceptance within 1 week. So that is the time which is specified by the offerer to the offeree, and while conveying his acceptance, he should convey his acceptance within 1 week. Then only it will be a valid acceptance. If he conveys his acceptance after 1 week, it is not a valid acceptance. So acceptance to be valid must be made within the time which is allowed by the offerer. And if no time specified, if offerer has not mentioned anything about the time within which the acceptance has to be conveyed, then it must be made within a reasonable time. Now, what is a reasonable time? It is a question which depends upon the circumstances of the case. So, as per the circumstances, which is the reasonable time, within that time, the offeree should convey his acceptance to the offerer. Acceptance may be made at any time till the offer is alive. Acceptance made after the offer has been withdrawn is invalid acceptance. So till the offer is alive means A has given an offer to B and that offer is alive for 1 week. He says that within 1 week you have to convey your acceptance. Means that is the period till which offer is alive, and if B conveys his acceptance after that 1 week means at that time the offer will be withdrawn. That will be invalid acceptance. So the offer should be made within the time, within reasonable time, within the specified time which is specified by the offerer. Fourth point, acceptance must be according to the mode prescribed or usual mode or reasonable mode. So whenever the offeree has to convey his acceptance to the offerer, he should convey that acceptance in a prescribed mode. Now, what may be the prescribed mode? Acceptance has to be made in the manner prescribed or indicated by the offerer. So, offerer may say that I want to sell my car to you for 1 lakh rupees, and to convey your acceptance, you have to write a letter to me. So, it is the mode which is prescribed. So it should be acceptance should be in a written format, written way. So this is the mode which is prescribed by the offerer, and offeree has to indicate his acceptance in the same mode, in the same way. Or A says that to convey your acceptance, you have to personally come to me and convey your acceptance. So this is the mode which is prescribed. Acceptance has to be made in the mode which is prescribed or indicated by the offerer. Silence does not amount to acceptance. So if the offeree accepts the offer but does nothing to show his acceptance, it is not a valid acceptance. Where offerer has not prescribed any mode of acceptance, then the acceptance must be expressed in some usual and reasonable mode. So offerer has not mentioned any particular mode of expressing his acceptance to the offeree in any way. Either offeree can write a letter, he can personally go and convey his acceptance, or through a telephonic call he can convey his acceptance. So in any reasonable way or usual mode he can convey his acceptance to the offerer if offerer has not prescribed any particular mode. Fifth point, the acceptor must be aware of the proposal at the time of acceptance. We have already discussed this point under essentials of a valid offer. What is the case law on this point? So acceptor means the person who is accepting the offer, he should be aware of the offer. If he does not know about the offer, how can he accept that offer? So we have already seen that offer plus acceptance, it will lead to an agreement or promise between the parties. But offer acceptance plus offer, no agreement. If the acceptor is not aware of the existence of the offer and he conveys his acceptance, no contract comes into existence. Which is the case law on this point? An act done in ignorance of offer of a reward cannot be called as an acceptance. Famous case law on this point, Lalman Shukla versus Gauridat. So, whenever any person does something, at that time of doing that something, he is not aware of the offer, then it is not a valid acceptance. He cannot claim any reward which has been declared about which he is unaware. Next point is acceptance must be given before the offer lapses or before the offer is revoked. Lapses means offer coming to an end. Time limit which is given by offerer for acceptance is 1 week. After 1 week, offer will lapse. Offer will come to an end. Or before the offer is revoked. Revocation means revoked means taken back. So offerer will take back that offer before the offer comes to an end or offerer takes that offer back. Acceptance has to be conveyed to the offerer. Acceptance must be made while the offer is in force. That is, before the offer has been taken back by the offerer or offer has come to an end. Next point, acceptance cannot be implied from silence. So silence never amounts to acceptance. No contract is formed if the offeree remains silent and does nothing to show that he has accepted the offer. If offeree does nothing to convey his acceptance, he has accepted it in his mind, but he has not communicated it to the offerer, it is not a valid acceptance and no contract will come into existence. Thank you.